Good evening and welcome to the sixth episode of our Community Action Network series of co-governance webinars. We host these sessions monthly on the last Wednesday of the month, and these webinars are really a space for local community organizations to learn how to expand some of the work they're doing and to really learn from each other. I'm Julia Fish. I'm the manager of the Johannesburg Community Action Network, known as Joburg Can, an initiative of ATA. If you have any questions for the panel, please make use of the chat and Q&A functions. Please also be respectful of each other in those chats, and we will get to them in the last 15 minutes or so. A bit of back and forth is always welcome, but we can only really put some pertinent questions to the panel, so please be cognizant of that when you put them in the chat. Please also take the time to introduce yourself and say which part of the country you're joining us from so we can cover as many of the municipal issues you're facing as possible. So tonight we're talking about development planning. This is one of the most expensive, time-consuming and frustrating issues facing residents associations, specifically around applications and problem properties. So in this episode, we will speak to three experts on the laws governing planning, common issues involving land use and construction in the communities that they serve, and ways we can work smarter as networks to achieve favorable results. The insightful discussion will provide practical solutions and strategies to help residents associations navigate the complexities of development planning more efficiently. So tonight, to help me discuss co-governance, I'm joined by Peter Murray, Director at Murray Incorporated Attorneys. Peter is a specialist property planning and administrative lawyer, and he's represented several RAs on planning issues in the city of Joburg. We also have Gemey Abrams. Gemey is a professional registered town planner and regional planner. And lastly, we have Rosemary Sandison, whose experience in the property industry ranges from town planning, regional planning, property valuations, property project evaluation, property management, company operations, company management, property research, property brokering, and retail. So let's get straight into it. Peter, if you wouldn't mind, I'd like to bring you in first. And let's really lay the foundations here. When we talk about town planning and land use, what are the laws that govern them at a municipal level?
Hello, everyone. Julia, thanks very much for having me on the show. It's really good to be here. We're fortunate in the current legal regime in that there's a piece of national legislation which is applicable across the country. That act is called the Spatial Planning and Land Use Management Act. It goes by the acronym of SPLUMA, and that really governs two aspects of development planning, which we'll come back to. SPLUMA then says that every municipality in the country must prepare two things. Firstly, every municipality must produce a SPLUMA bylaw, and every municipality must create a land use scheme to cover the entire area of the municipality. So as I said, SPLUMA really regulates two aspects of town planning. The one is what we would call spatial planning or forward planning, and that is really the vision of the municipality for how the municipality wants the city to develop and where they want development to take place and what kind of development to take place. The other aspect is land use management, and land use management is more the current realities on the ground. Each property has a zoning. You must comply with your zoning. And if you want to change the zoning, how do you go about changing the zoning? So if we look at those two pieces of legislation in a little bit more detail, and again, there might be small local or regional variations, but generally the processes are fairly standardized across the country. SPLUMA and the SPLUMA bylaws in each instance will say that if someone wants to change their land use because they want to develop their property, they need to submit an application to the municipality, and the bylaw tells you exactly what documents must accompany that application. The question then arises as to how does one become involved in the public participation process? Because SPLUMA, the bylaw, the land use schemes are all rich in public participation processes. These are very democratic processes. They don't happen in the dark, and they don't happen without community input. So it's important to know how that community input is structured and how we can become involved in that community input. As I'm sure most of us know, the first way in which one can become involved in the public participation process is to submit an objection to the land use change application, to the development application. The question arises, who can object to development applications? Here one needs to be a little bit careful. Some of the bylaws, Johannesburg, for example, says that in submitting an objection, you have to say what right or what interest it is that you're seeking to protect by means of your objection. But generally, anyone can object. Obviously, you need to be a member of the local community. I can't sit in my house in Johannesburg and object to a development application in Cape Town and vice versa. It's got to be something that affects you. You've got to have an interest in it, and that development the proposed development must have an impact on you. Anyone can object. So generally, I would say every RA should object, but I don't think, often what happens, I see, the RA will object, and then property owners in the area will say, I haven't objected because the RA has objected, so there's no need for me to object. My view on these things is everyone who is in that local community should object. It just gives you a foot in the door, and it gives you a right to be involved in the public participation process, which you won't have if you have objected. My other piece of advice would be, often we see, there's a lot of hype around the fact that there's a rezoning application in our suburb, and everyone gets hot under the collar about it, and everyone objects, and then it all goes quiet. Then we do nothing. We do nothing about the objection. So my view is that the objection letter is simply the start of the public participation process, and it's really important to keep on being involved in that public participation process. How do we do that? I think firstly, it's really important for communities, for neighborhoods, to have an understanding of what the spatial frameworks, what the spatial plans for their area are. So I mentioned that Splume and the bylaw do two things. The first thing is they look at forward planning, spatial planning. So each municipality produces a spatial framework. They have different names. In Johannesburg, as we all know, I'm sure a lot of people have dealt with it, we have the nodal review, which supports very aggressive densification. In Ekurhuleni, you have MSDFs and SDFs. So it's not that easy to understand. You're looking at very large documents, and it's not just one document. In Johannesburg, we've got the SDF and the nodal review. So it's quite hard to understand how they hang together. And my advice would be, this would be an area where it would be very useful to spend money. I know it's always a question of resources. Spend money on asking a town planner to look at the local area frameworks and to give you a summary and a plan as to what is applicable to your neighborhood. Then you can take the rezoning application, you can compare it to the spatial development framework for your area, and you can say, is it consistent with the spatial development framework, or is it not consistent with the spatial development framework? And I think that's important, because I think, we need to find a balance here. It's not a question of every development is bad. Obviously, we all need developments, and we all use developments every day. We live in houses that have been built. We go to hospitals that have been built. We go to schools that have been built. We work in offices that have been built. But it's a question of having the right development in the right area. The other thing that I've found in practice is there's almost a way of doing things where the applicant has a lot of input into what's happening at the municipality while that application is being processed. So the application is allocated to one particular town planner in the municipality. That town planner will circulate the application to all the technical departments, to electricity, water, roads, etc. They'll have an opportunity to comment on it. The comments will come back. There's a lot of liaising happening between the applicant and that dedicated town planner within the municipality. But I feel that town planner is available and should be available to everyone. So rather than just getting your objection in and sitting back and waiting for the hearing to come up, speak to that planner, ask that planner, what comments have come back from the technical departments. These are our concerns. This is what we'd like. This is what we wouldn't like. I think that kind of liaising with the municipality is a little bit missing in these proceedings, and I think it could definitely help. The other piece of advice I have in these procedures, because they can be very drawn out and they can be very complex, is to speak with the applicant. Time and time again, we have a situation where there's a rezoning application and people go, the applicant is that developer is the enemy, and we're not speaking to them. You'll be surprised how useful it is to meet with the developer, to understand what the developer's requirements are. Why does the developer want this development? is the developer negotiable on certain aspects of the development which will have negative impacts for the residents? So I think that sort of interaction is a crucial part of the public participation process. And I think not enough people make use of that. Then what Spluma and the Spluma bylaw says is if we've got objections to the application, you get to the point where you can't resolve the objections, and then there's a hearing before a tribunal called the Municipal Planning Tribunal. That tribunal will hold a hearing. It'll hear from the applicant. It'll hear from the objectors. And again, this is, one needs to look at these MPT hearings carefully. It's very easy to fall into a very adversarial situation. And I don't think that's always a really, it's not always a constructive or productive way of doing things. Again, this might be a point where you want to spend money on the process. So you might want to look at all of the engineering services issues like the roads and the town planning, the height of the building and the size of the building and the type of the building, the sewer system, the electrical system. And you might want to brief your own expert, an engineer or a town planner, to go to the hearing and to make representations at the hearing insofar as engineering services and impacts are concerned. If one is not happy with the decision of the Municipal Planning Tribunal, there is an opportunity to appeal that decision. Again, I don't think many people are fully cognizant of the right to take it on appeal. I have seen people getting MPT decisions before and it goes against them. They say, oh, well, it's over. You certainly can appeal that decision and go to the appeal tribunal. Each municipality has a different appeal tribunal. In Johannesburg, it's the MMC for development planning, and you can appeal that decision. So that really is that's the legal procedural framework in terms of which development planning occurs. Obviously, there's a huge amount of detail in all of this, and there's, we could speak about it for hours and hours. So unfortunately, that's a very high level, rough outline, and I've tried to identify, areas where I think, we could be, as communities, we could be more involved in these public participation processes because they are there and they are available. And really it's about talking to all of the role players, the municipal role players, talking to the developer and seeing if we can't come up with a development which is going to serve the community rather than having unacceptable inputs on the community. I think I've covered all my points, but obviously lots more to discuss. So I'm happy to answer any questions about that very broad legal framework.
Thanks so much for that, Peter. And for some actual real elements that communities can look at when they're doing their objections and when they're participating in this process. Please, you're encouraged to ask any questions in the chat and we'll get to them in the last 15 minutes or so. Gemey, if I can come to you now, you've played a key role in drafting Spluma, which we've just spoken a little bit about, its regulations and, of course, the provincial acts that feed into it. You've also been on the Emmarentia Residents Association's executive committee for nearly 25 years and support neighbouring RAs, such as my own in Melville. And from that perspective, in your capacity as being a member and consultant to residents associations, why must local groups understand this legislation? The nodal review, in particular, that Peter mentioned briefly there, has become almost a swear word for RAs. So why has it created more work for communities wanting to protect their built environment?
Thank you very much, Julia, for that introduction, and good evening to everyone and for taking the time to join us. Yeah, I was asked to talk a little bit about the planning issues that residents associations and residents grapple with, and I thought, well, where do I start? And I think that I'm sure we've all been faced with, and this is what's happened in Emmarentia as well, where there's been illegal land uses on a property in your suburb. There's been illegal buildings, people doing extensions and building illegally on their properties. Maybe a property with too many tenants, often noisy, or a house being used as a business, or a shebeen opening up in your street. Road closures in your area, illegal advertising on the property walls, pop-up restaurants. These are all things I'm sure we're faced with, or you haven't been sure whether you need to get planning permission, say, for a borehole, or if you can have a second or even a third dwelling on your property. Can you run your business from your home? Can you rent out your cottage? Can you object to a rezoning, which will be more the focus of today? And all of these, relate back to town planning. And they can be frustrating for residents and make us feel quite despondent at times and even angry. So I thought Peter has done such a fabulous introduction that I run the risk of duplicating a little bit there, but I think these are points worth making. And you might ask why I do this. Why have I bothered for 25 years to support ERA? But I think it's very important to have a residents association in your area. And I think it's important for your residents to know that there are people who really care about the suburb and somewhere they can go to assist them with the concerns. So I was going to explain how planning works, but I think Peter has covered that. And it's just important to know that the municipal planning is a function in the constitution for municipalities. So it is the municipality that sets the bylaws or the laws around planning. They set the policies, they draft them, they amend them, they approve them. They set out the procedures and they make the decisions. So it's those four main important aspects. And Peter's also said that there's quite a lot of scope written into the law for public participation. You have rights to participate in this process. And I feel very strongly, and something I've done all these years in the Residents Association, to make sure we comment on any changes in the bylaws, the legislation, in the policies. The Spatial Development Framework in Joburg recently went through a review. Put comments in where you can. And so there's the spatial planning side of things, like the SDFs and that, where you can comment on in the laws, but there's also then the development management, as Peter has mentioned. And it's important to understand that these two are linked. And because when it comes to the planners making a decision, or the tribunal making a decision on that rezoning application or change of land use, they will go first to the law, even the principles in SPLUMA, what the bylaw says and what the spatial plans say. And if it is in line with these, the planners are more likely to support the application. And one of the most important plans where this interface happens in Johannesburg is around the nodal review policy. And Julia, you're quite right. It has become a challenge for us as RAs and for the residents, because it's now approved as part of the SDF. So it's an approved policy of the council. And it's a policy that identifies a whole lot of nodes. We've always had nodes in the SDF, from your big CBD to the industrial areas, to your Sandisons, your Rosebanks. Those are all the policies. Those are all the nodes that are identified in the nodal review. But when it comes to our suburbs, they sort of have broad brush, all the former white suburbs, all our sort of suburbs that are close to these nodes have all been painted with the same brush of either a general urban zone or a suburban zone. And so there's thousands and thousands, tens of thousands of properties across Johannesburg. I'll hold up this plan to the camera where you see everything in yellow. The CBD is down at the bottom here, and all our suburbs is the yellow and a little bit of green in between. So every single property within the general urban zone and the suburban zone is now designated for higher density development, that's residential densification, mixed use. And while those things are not bad, as a planner, they are quite sound international principles, because you want to promote a more efficient city, better public transport, and those sorts of aspects to our metropolitan area that is growing all the time, by the way. I don't know if you saw the latest Stats SA figures. but often it's the interpretation of that general urban zone and the suburban zone that's causing the problems for us that live in these suburbs. And so I think that the other aspect of the general of the nodal review is that it's sending a message out to developers, whether it's a small developers through to your big developers, that the city wants to see these areas developed and wants to see densification. So we are getting rezonings in these areas. And so, you know, we have to be on the lookout for these rezoning applications. Also, because the nodal review also withdrew a lot of our precinct plans and the local area plans or the strategic area frameworks. And so, you know, it all hinges now on this nodal review plan. And what happens very often is that because it's such a broad brush zone, the actual local circumstances of that little site that's being rezoned often tend to get overlooked very often. So we have to look out. We have to look out for that. So we are seeing changes in our suburbs with applications for mixed uses, for shops, student accommodation, boutique hotels, townhouses, all this kind of thing that we weren't faced with as frequently before, or that we had local plans that directed it onto corridors or into specific nodes and protected the residential areas from these sorts of developments. And that's not really the case anymore. So I think that, as Peter said, I think we are all reasonable people, and we do support a lot of good changes in our suburbs. We want them to move with the times, and we want to see more residents coming into our area. So we're just asking that these policies be applied with discretion when it comes to the local area. So when it comes down to how this is affecting the rezoning, Peter's gone through some of this, but those white notices that go onto properties, they're A3 size, they get put on the fences. Please, residents, you have to look out for those and take photos and let your residents association know, because those notices are important. They are the notice that tells you what is going to happen on what they've applied for, what's going to happen on the site. But most importantly, the clock starts ticking, and you get 28 days, and there should be a date on there that says when you can object by. So it's very, very important that the community engages with it and knows about it. Then you need, as an RA, to try and get hold of that application and see what the content is. And that's very difficult at the moment with the municipality. And so call up the applicant, introduce yourself, you know, as Peter said, you be pleasant. It's not necessarily adversarial, and get the information and ask if you can come back to them and inquire, because they would like nothing more than to have any disputes resolved without it having to go to tribunal. And sometimes there is scope for that. On Barry Herzog Avenue in Emmarentia, we negotiated every single one of those townhouse developments to make sure that they were in keeping with Emmarentia and that type of thing. It was done. We very seldom went to tribunal on any of those. So it can be done. So just to say, then you've got to notify your residents association and help the residents to put in objections if they feel they are affected by the development. And you can do that by offering some guidance on what sort of things, because we do have to give reasons. You can't just say, I object, full stop. You have to, as Peter was saying, you've got to have some sort of locus standi, and you have to have some reasons. So that is quite important. So get your objections in, get it written in, get residents to write it in their own words, and then, you know, depending if this is a really impactful development, you may need to get a planner or an attorney or some specialists, and this will cost money. And residents associations, it's a frustration. We volunteer organizations. I'm a volunteer. We all volunteers. We have busy lives, and we also don't always have big memberships. So our coffers aren't that big to start paying for specialists and for paying for that. But
Exactly.
sometimes it's worth it. I'm finishing off now just to say that when there is if you do not object, which is your right to object, just like it's the applicant's right to put in an application, it's your right to object. And if you don't object, that application does not go to the tribunal. It gets decided by an official who's an authorized official to decide. And it's usually the planner in the area that writes a report and recommends it, and then it gets decided by the head of department. So your voice is not heard then. So if you go to tribunal, it's a bigger committee, it's people with different backgrounds on that tribunal, and it's not a court of law, it's administrative. You don't have to feel intimidated. You can go there and give your reasons and let them see how, give a heartfelt objection to how this affects you. So I like the points that Peter made as well about engaging and also understanding that there is this ongoing discourse and discussion that's happening between the planners. And it is unfortunate, that we do have planners allocated to our area. And it would be so nice if those planners were, if the institutional setup was more friendly towards us as individuals and as residents associations. So you had your friendly local planner as part of your team or someone you can go to for advice, but you have to develop that relationship for it to help. So you go
Thanks so much, Gemey.
Yeah, sorry, I have gone on a bit, but just to say, please exercise the rights that you are given through the laws, and strengthen your community through this action. Thank you, and I'll take lots of questions later on. Thanks.
Yeah, we'll try and get through as many of them as possible. We've got a great few coming through, and we'll talk specifically about, the practicalities of enforcing all of this in that chat. Thank you so much for that, Gemey. Rosemary, you've got also over 37 years of experience in property field, both here and internationally. So what are some of the vital reasons that communities need to know about these laws? And when we really talk about public participation, what does that mean? And really, where are we with engaging communities on making sure that these laws reflect what we want?
Yeah. I think that's come through on the principal level, which I'm very grateful to Peter and Gemey for going through that. I'm going to go through a little bit of the practical, what happens on the ground. But I have to stress as well, familiarizing yourself regarding planning legislation is a great idea. But however, it's very boring to most people who aren't where Gemey and Peter and I are. And we find it very interesting, but most people don't. But please make the effort as communities. You might regret not having gone to some of those public meetings held by the council when you start seeing the white notices on the properties next to you. So Gemey is absolutely correct. Please make an effort. And I'm going to go through towards the end of my presentation on some of the practicalities that residents associations or interest groups or community groups can do to make that a lot easier for yourself. Excuse me, coughing. Generally, public meetings are not inviting places, and I don't know whether it's on purpose or not, but generally not presented in language that the man in the street might understand. But please ask questions when you do attend these meetings. Ask as many questions as you would like to. That's your right, and also involve your counsellor. If you haven't been satisfied with the presentation that you've been in a public meeting for example, a change of legislation or whatever, a change of bylaw, and you've been fobbed off by some of those officials who like to fob residents off because they sometimes regards residents as not knowing what they're talking about, engage your counsellor. Put your comments in writing, put your concerns to the communities in writing. And if you don't want to do that as a member of your community, hopefully the community have enough funds to send somebody, as Peter suggested, on your behalf to interpret the presentation and how that will affect your area. And this goes to what I want to say up front. There are two things that are very necessary to to protecting your areas and protecting the values and the reasons why you bought into your area. Communities need to start saving money, because this is going to become, in my view, it's going to become more and more prevalent. Start saving money for these actions, and start getting your community involved in understanding what's going on. And the third thing, which is the most important thing, is persevere. Please persevere. You will have to, because you will be treated not well by many council officials or by disinterested developers. Gemey's right, some developers are very open to discussing it, and others, I'm afraid, not so open to discussing with residents. Often residents are perceived as nuisances. The right and importance of public participation and the requirement of any municipality to give effect to the community's right for meaningful public participation is legislated. It's your right, so persevere. However, I have to say that there is a lot of community apathy when things start becoming too confused or too difficult. There again, I would say, please reach out to groups like OUTA for support, and they will point you in the right direction. I'm not going to repeat a lot of Gemey and Peter have said. I'm going to go on to a little bit more of the actual process in objecting to an application in your area. Those little white notices, and somebody's mentioned they get hidden behind bushes, exactly right. Take a photograph of that. But and I'm going to say it now, I've added it further on in my presentation, but my suggestion is, in your communities, make WhatsApp groups and call it a notice WhatsApp group, so that everybody's on the same page. If anybody notices a notice anywhere, it could be in a school parking area, which somebody is not going to see, but somebody has seen it. Please take a photograph and post it on that group, and everybody can start discussing that issue. My view, I would employ perhaps not a town planner. I'm a retired one, but I wouldn't probably employ a town planner for this issue, because certainly in places like Johannesburg and Pretoria, town planners make their living from developers. So a lot of them don't want to be seen to be fighting with a developer. Also, they have to work very closely with the municipal officials. So in my view, it would be much more effective to employ a lawyer, an administrative lawyer with a planning history, planning property background. So once you've put your objection into an application, and as Gemey says, you must do it on time, you must give your reasons, and you must say why you're objecting and where you live. You must say your address, all those sort of things, which are quite logical. But the COJ will then call you to a tribunal, and the tribunal may very well be a year or two later. It has happened where the tribunals only come up much later. I agree with Peter. Try and engage with the town planner who's handling that within the council. Often they won't want to talk to you, but there again, persevere. Just persevere. Try and speak to them. Try and find out what information they're getting back from different areas of the city authorities to that application. When the tribunal is held, it's only held with the objectors present after the city has processed the application and has already written their recommendation, sometimes without even having been to site. So be prepared for that. And I'm afraid in tribunals, it's quite common for the person who's written the decision of council to choose not to change their view. It does handicap, in my view, public participation, because the decision has already been made within tribunal. Many tribunal members also do not appear to be very interested in the matters under discussion. And as I said earlier, often the objectors are seen as a nuisance. Put your big girl panties on and go to those tribunals and have your say. It's very important. answers have to be given to questions raised by communities at the tribunal. And if they're not forthcoming or satisfactory, the municipal decision may be appealed. If you're not getting answers, if the decision goes against you as a community, you have every right to appeal. Appeal, somebody asked the question, yes, to appeal it does cost. To ask for reasons for the decision taken by the tribunal if it's gone against the community, you also have to pay for that. But one of the things that I would say is start fundraising very early, because this is going to affect all communities. Our policies are impacting the communities that aren't outside the urban development boundary. So I would say, please get your collective groups together and start raising funds now. Also, residents, if you're individuals and you want to protect your own properties and your own property values, start putting aside monies to put in a little slush fund that you might need to employ a town planner or to appoint to give you advice, and then a lawyer to represent you at any tribunal. Appeals, unfortunately, are processed within the councils, certainly in the city of Joburg, by the same team who makes the initial decision. Yes, it's the MMC who signs such decisions, but the MMC is generally not a town planner. So he's taking advice from the people who've already made that decision, and very often the appeal process has become just a process that you have to go to if you want to go further on, and your route further on is then to go to high court. Unfortunately, in tribunals, there's very little independent voice in both the decisions and in the appeals. City of Joburg, unfortunately, and I'm using City of Joburg now. I apologize for people living elsewhere, but for City of Joburg, unfortunately, they regard the Joburg Water, Joburg Roads as independent parties, but unfortunately, their sole employer is the City of Joburg. So in my view, I certainly don't regard those as independent. Appeals can be costly, but they're worth it. They're worth it because you're going to prepare if you need to go further. As Gemey said, often somebody gets the result from a tribunal and then they don't take it any further. It's unfortunate, but I think our communities have to start becoming far more proactive. If you want to retain the character of your area, you have to go through this process. It's unfortunate, but it can be effective if you go the whole way. Infrastructure and environmental impacts in communities are often not considered with the seriousness they require. So when you're making an application or an appeal, get your professionals involved, get environmentalists involved, get engineers involved, because the impacts will be on the local environment, and they will impact you, and they will impact your values. So appoint the correct representatives. There again, go to OUTA, and they'll probably point you in the right direction. What to ask when you're in tribunals? Do I still have some time, Judith?
Because I'll give you 1 minute.
Oh, I'm going to get to the significant points then. There are a number of procedures that you could do to protect your area already. Some creative examples are you can create a community of interested neighbors who care about their investments and start fundraising for the threat, which will be coming. As I've said, set up a public notice WhatsApp group. Get street champions to have workshops in identifying what form of planning you want to see in your area, what character you want to preserve, density, identify risks, get everybody on the same page that you can, get buy-in from many residents as possible, and create your planning committees from your local skills in your community. An example is entrench and identify new title deeds that collectives are very happy to put into the title deeds. You only have to make your area disinteresting to developers or expensive, and they'll look somewhere else. Identify features, for example, historic, environmental. Get professional bodies to help you identify that in your area. get protection from local and provincial authorities. It's possible. We've done it in Lone Hill. Lone Hill didn't have any protections when it started, and when the threats were coming. Lone Hill's done it. Emmarentia managed to do it. Croc River Reserve, which is out north of Lanseria, a very, very sought after area, has managed to get nature reserve provision. That took them 10 years, but they did it. The point is the group got together and they worked at it and they achieved it. They didn't give up. Some suburbs have done similar. I know in Kalami here, we've put conditions into title deeds in areas where there was a development threat. They didn't get 100% people putting them in their title deeds, but it was an area big enough to make a developer look somewhere else. That's all you need to do. You only need to get a developer to look for somewhere else. It makes the targeting of your area less attractive and makes them go somewhere else. There are ways of doing it, folks, and I'm very happy to engage with any questions from that thereafter. Thanks, Judith.
Thanks so much, Rosemary. I came into this work from being on my own residents association in the land use portfolio, so I understand a lot of the frustration that people feel when it comes to, trying to really engage with the city on planning issues. So when we're talking about like town planning and development, we often get this kind of feeling that, it's a bunch of NIMBYs, not in my backyard, is saying, I don't want this, this is not okay. But really, there are actual impacts here when we talk about service delivery, infrastructure management, environmental management. We get encroachments into green zones, for example. And one of the big things that comes up in the tribunals is these letters, and it's come up in the chat as well, from entities that provide water and electricity, that there's an endless supply and there can be all these developments. So why is it important that we actually apply some oversight and accountability in the planning space? And this is for all of you. Peter, maybe you'd like to attack it first.
Sure, thanks very much. I've been reading the comments, and the one that really struck me is that these procedures are very cumbersome and complex and difficult to follow. And I agree with that. I think if I'm involved in this all day, every day, so it seems rote to me, but I understand it's not for people. I would advise try and simplify this in such a way that you have one position in your community that you can reuse. What I mean by that, firstly, often I will find an RA gets involved and the community gets involved, and then I say to the RA, if it's an association, show me your articles of association. If it's a nonprofit company, which I strongly suggest you should have, show me your MOI for the nonprofit company. And I look at it and says absolutely nothing about town planning. Your start point, your foundation is absolutely essential. Write into your MOI that the purpose of this NPC is to oversee town planning matters in this neighborhood, and you define the neighborhood. Then you're in a much stronger position. I saw the other question, which I think is a really good question. How do we get the municipality to notify RAs of rezoning applications? There are quite a few court cases, unfortunately, that say there is no legal obligation on municipalities to do that, and I agree that's the correct legal position. But if you have an MOI that says this is our role, this is our function, and you write to the head of development planning and you say to the head of development planning, this is who we are, this is what we do, we want to be notified of all applications within our area. The head of development planning will say to you, we don't do that, but the point is you've got that letter, you've got on record. It's really, he who shouts the loudest gets the most. You need to be an activist, you need to be in the face of the municipality, you need to tell them you're there and you're not going away. And you're not there to make trouble, you're there to oversee the developments that are happening within your area. So I think having that kind of foundation in place is absolutely critical. Then when I talk about reusing, and again, the nodal review has caused endless problems. It says that the city will support a very aggressive densification policy, and if you look at your neighborhood, you'd be absolutely aghast at the kind of densification which will be supported. Take a suburb like Parkhurst, each stand is the same size, 495 square meters. In Parkhurst, the nodal review says it will support 5 units per earth, which is just astonishing. How do you fit 5 units on a Parkhurst earth? So what I would do, and again, this is, a lot of this is about scarce resources. What I would do is, and I've said, I would spend money on getting a town planner to explain to us, our neighborhood, what are the municipal policies for our area, and to show it to us on a plan. So that's something you can reuse. Secondly, because of this massive amount of densification, and the other thing that municipalities have done is, from a legal point of view, they've made it really, really difficult for communities to come up with their own precinct plan. It is a hugely cumbersome procedure that costs multi-hundreds of thousands of rands. I can't see that any community is ever going to get a precinct plan approved for their community again. But it doesn't mean you shouldn't prepare one. I think you should look realistically at your neighborhood and say, again, this is where I would spend money. Get an expert town planner or urban designer in to draw up a precinct plan for your area. Make it realistic. Make it align with the nodal review. Make it align with the SDF as much as you can. Then you present it to the council. You go to city transformation and you say to city transformation, this is what we want for our area. We know it's never going to be approved as a precinct plan, but we want you to understand that if something is not in line with our precinct plan, we are going to object to it. And you can reuse that precinct plan again, and again. And so you've spent money, but it's going to pay dividends in the end. Someone also raised the dreaded I word, infrastructure. I know it's a huge issue, and it does come up again and again and again. It's not correct to say that the municipality approves anything. You can look at an area like Bryanston, one of the biggest suburbs in the country. The city will not approve anything in Bryanston, not a subdivision into two, at the moment, because of the water constraints. Those water towers in Bryanston are 200% over capacity. And again, this is another area where I would spend money. Get engineers, or if you have engineers in your community, let them give you a report. What is the status of the infrastructure in our neighborhood? What is the status of the electrical supply? What is the status of the sewer capacity? What is the status of water? Those are reports. Again, every time you have a rezoning application, you refer back to them and you say, in terms of our report, because we know scientifically, empirically about our neighborhood that there's no capacity. Then you can't have the wool pulled over your eyes by City Power saying, oh, it's fine, well, there's lots of capacity. So I think the absolute buzzword for me would be reuse. Get these things, get a plan, get these expert reports, get your MOI in order, because those are things you're going to be using again and again and again. And I think if you get yourself into that position, the whole process becomes a lot less complex and a lot less difficult to navigate, because you're not reinventing the wheel every time there's a rezoning application.
Rosemary?
Thanks, Julia. While we've been talking, I obviously have people sending me messages quite often. Their comments are so in line with the number of comments we've had from residents in here. And I remember at one stage, somebody asked how many applications are rejected. I remember at one stage I was given the statistics: out of 200 applications, 2 were refused.
Mm.
And that's what we're looking at. We're not looking at critical thinking happening when applications are approved. We're not looking at impacts on surrounding areas. We're not looking at impacts on environment. And I'm talking only Joburg, so I apologize to those elsewhere. But that's what's happening in Joburg. So good.
And we're not looking at heritage, which is a big one as well.
Absolutely. So well done for exposing this, because I think there's a real need here for communities to start talking to each other, to start looking at methods to help each other, because they're all under threat.
Gemey?
I can come in there. There's so much I didn't get to say in mine, and respond to what the questions are as well. Is that a lot of the problems start with things like estate agents selling properties for something that they know probably wouldn't get approval for. So in our RA, I've always tried and develop relationships with the estate agents as well, to the point that they would phone me to say, I've got a buyer who wants to do this, is this acceptable to the Residents Association? And often I say no, and they let it go. It doesn't always work, but I think it's useful to really build those relationships with the estate agents and have their support. They also are the eyes and ears of what's happening in the market in your area as well. So that's useful. Then you get the illegal uses. So that we need to know as residents and the RA, how do we report these? What is our responsibility? And there is a single law enforcement email address for each of the regions. And so you can report building, land use, illegal advertising, all these things to the single law enforcement. And you can send it, you should also have a relationship with your building inspector. I'm so happy to see Heather's on the forum here tonight. She'll know much more about all the building plan side, but you have every right to report this to single law enforcement if you're concerned. What I do is I try and send photographs, give the property description. A very, very useful tool is the city's GIS. It's a fabulous resource, and you can link to it. The GIS can show, you can click on every single property and it will tell you the address, it'll tell you the earth number, it'll tell you the owner, it'll tell you what it's zoned for. If you go to the zoning layer, it will even tell you what rights have been approved since the original zoning. So it's a fabulous resource for us to use to engage with the city. So please, please report these things. You can get moaned at. I got moaned at the other day for sending building inspectors out to a property, and they said, "Oh, there's nothing wrong with it." But it's crazy, you put your hand up to be on the Residents Association, and it's not, you get flack sometimes. So it's about anticipating that someone's going to buy a property and probably use it illegally, or they're already using it illegally. You have a right to object to these things. And then what happens is then they get fined, or they get the inspectors come out, and so they're told to rezone it or go for a consent use, or get the building line relaxation and all these sorts of things. So a lot of the applications are also rewarding, in a way, inverted commas, someone who's been acting illegally and really caused this disruption in your suburb. So then, and it's not an argument. You can't go to the tribunal and say, "Oh, but they were illegal," because they are in the process of regularizing it. It's not a sound planning argument. So it is frustrating for us when there are those sorts of applications. And I think that Rosemary mentioned that planning report. When you are notified of the tribunal, you get 2 weeks, you get the notification. That's if you've put all your email address and all your details, which is vital. And at that time, they will tell you that there is an agenda for the tribunal, and somewhere in that agenda will be your application, and the tribunal administration, the officers there put together all the the application, the objections, and included is that report from the city planner, as well as the service departments. So often it's only 2 weeks before that you get to see that. But if you do talk to the planners beforehand, get them to send their report as soon as possible, and you can see what your chances are because they make a recommendation. So I think that Peter and Rosemary have honed in on some very, very important things that frustrate us as planners, and the planning report being one of them. Doing a precinct plan. We've been trying for years to get a precinct plan, but it is a difficult process and you need a lot of money. But it's becoming more and more important now the nodal review is there, because the local situation isn't always taken into account. I've been campaigning for many years when we put in submissions on the SDF or on the legislation to get the nodal review policy to be taken out of an approved part of the SDF and make it a guideline to support the decision making of or to apply the SDF. I've applied for the planner's report to not make a recommendation. Let them state the facts. Let them say, yes, we received so many objections. Yes, the property's here and it meets with the nodal review or it doesn't. And also to get precinct plans done. So keep on, eventually, as Rosemary said, eventually maybe some of the things you comment on will stick. Slowly you get a few changes here and there into the planning bylaw. And so, yeah, it's frustrating, but we have to keep plugging on in this.
There was a question, Julia, what is a precinct plan? So all of the policies that we're talking about, the nodal review, the SDF, these are huge citywide policies. They cover massive areas. They can't possibly get down to the level of detail of what will be supported on a specific earth or a specific street. So a precinct plan is a much smaller plan. It'll deal with one suburb or two suburbs, and it'll give far more detail than the SDFs and the nodal review do. And again, because of the short notice that we get for hearings, for tribunal hearings, it's critical to have that in place already, to have all your reports ready, that you just take them out and reuse them every time as it comes along. And we have, talking about law enforcement, we have had successes where we do, each area has its own law enforcement officer. You need to know who that person is. You need to have their cell number. You need to phone them. You need to meet them at the site, show them the illegal land uses. We've had examples where people are building without approved building plans. Or other day we had a matter where someone was happily demolishing part of the wall on Munro Drive, which is a 100-year-old wall. And we got FRAG and we got law enforcement in, and it stopped and the person rebuilt the wall. So it's not all gloom and doom. It's not like, it's not as if nothing happens.
Can I just add, sorry to interrupt, Peter, but I just see we've got short time. Just related to that with the illegal buildings that do come up. And I know it's very, very frustrating for residents and it's frustrating for the building inspectors as well, because they'll go out, they'll issue a notice, and then they'll just get ignored. And I believe that the building inspectors have been told not to incur any more legal costs for the city. So their hands are also tied. Some of them are very great guys who try and do the best they can, but when their hands are tied, then the illegal buildings remain.
My advice would be to choose your battles carefully. So obviously you can't go to court on every single one. Choose one in your area that's really prominent, a really bad land use. Take that to court, get your court order, get the court order interdicting that illegal land use. It'll change the landscape completely. People will then think twice before they do that again. And remember, all of these contraventions are criminal offenses as well. So together with your High Court interdict application, you go and lay a proper charge where you properly set out what the criminal offense is, and you lay criminal charges. Promise you, do one of those, it'll change the landscape in your community overnight.
That's right.
So to answer some of the questions, I've seen wins. In my community, we've made sure that we had a precinct plan. Yes, it is ignored by the city, but we've got that information there. We've said we do allow development. Development is a great thing for the suburb. We've got to bring money into the suburb, but do it here and develop these properties and go in with nodal in those ways. And it really has formed a massive part of a lot of our objections. Peter's just worked with me, Gemey's just worked with me on winning a case in an illegal wheel alignment center that popped up in a house. We won that case at tribunal. It was the first one in my 2 years with the MRA, but we're getting there and we're making those moves. There's a property here in Melville, which has been empty for, I think it's going on 8 years now, because they demolished it illegally and they've been told they have to rebuild it. So, of course, they're now dragging their feet to rebuild it, but nothing is allowed to happen on that site. And it's those kind of wins that we can really go for. We're quite cautious in these sessions to give costs and explain why, like how much these things cost, how much it takes to take things to tribunal, because they can vary quite wildly. It depends on the complexity of the case. It depends on some of the documentation that Peter said. If you have these at hand, they really do help. So try and get a lot of the procedures and the processes as residents associations in place. We'll put out a resource on our web. Yeah.
Not saving the money.
Like we said in the introduction, this is a very costly exercise for residents associations, and it's really becoming a frustration, and the time and effort that have to be put in by volunteers is immense. So when it comes to those kind of things, we'll put a resource on the Joburg CAN website so you can find some of this legislation. We spoke about a lot of the laws, and they're complex, they're complicated, but we'll help you with where to find them on the city's websites and where to find those bylaws. Like we said, it's really important to participate in these. In the IDP process, we put forward that the penalty rates applied to illegal properties, illegal building, illegal land use was not enough. And we got a concession that those have now in the city of Joburg be increased to 12 times rather than 4 times. And I think we're going to start seeing a lot more compliance when it comes to really putting up with these notices that the single law enforcement entities are putting across. And it's that kind of participation that's going to start turning the tide in development assets. So I'd like to thank our panelists tonight for taking the time to join us. And to you, the participants, for engaging in the topic. I hope we answered most of the questions in our conversation. But if you have any more, or you'd like to reach out and find out more about what we do, you can visit joburgcan.org.za to get updates. The recording of the session will also be there. You can also email me directly. And please make use of the report corruption option on the outer website. When you are gamming up against issues in these municipal planning tribunals, you want to tell us about some of the issues you're having with the law enforcement entities in your area. Bring the evidence, we'll chase it up. Furthermore, we encourage you to sign up for our newsletters, find out more about these conversations that we're having. And we hope to have a lot more of these conversations in the coming months. So please do engage with us and let us know what kind of topics you'd like us to revisit, because obviously an hour is a very short amount of time for us to get to everything. And these are very complex issues that we'd really like to help communities engage with. And it's creating that network when we're connecting each neighborhood to each other that we can concisely work together. I see a lot of the RAs in the room that we work with, and I think it's that concerted effort that will really start making a difference. So this has been the 6th episode of the CAN Co-Governance series. From me, Julia Fish, and the whole Community Action Network team, thank you and good night.
Thank you. Good night.
Thanks. Thank you.
Thank you.